Zuber and Company, fire forensic experts and forensic engineers. Seeking answers from ashes. Seeking answers.
You know that feeling, right? You're staring at some long contract full of dense legal jargon, that tiny, tiny fine print. You just sign it. You trust that the company is going to do right by you. But what happens when that fine print isn't there to protect you? What if it's actually a trap? Well, today we're going to break down a wild court case where that's exactly what happened. This whole story really boils down to one big question. Can a company legally take your money for a promise that, it seems, they never ever intended to keep? It's a question that cuts right to the heart of what's fair, and the Supreme Court had a lot to say about it.
All right, so let's get into it. The whole problem starts with the contract itself, a document that was basically at war with itself from the moment it was signed.
So, on one side you have Texco Marketing, a small business just trying to protect itself. And on the other, the massive insurance company Tata AIG. It's a classic David versus Goliath setup. Texco does the responsible thing. They go to a big, trusted name for a standard fire insurance policy. Seems pretty straightforward, or so you'd think.
Okay, so here is the kicker. This is where it gets completely absurd. The policy Texco bought was for their shop, which was in a basement. But buried deep in the fine print of that exact same policy was a clause that said the policy does not cover basements. I'm not kidding. The contract promised to insure a basement shop, while a clause inside it said basements weren't covered at all. And you can't even chalk this up to some kind of mistake. No way. The insurance company, Tata AIG, knew exactly what was going on. I mean, their office was literally across the road. They sent someone over to inspect the basement shop before they even sold the policy. Then they inspected it again after some construction. On top of all that, they were already insuring another basement shop right nearby. So yeah, they knew. They absolutely knew.
With a contract that's such a ticking time bomb, you just know it's going to go off eventually. And, well, it did. Disaster struck.
So let's just walk through this. Texco buys the policy in July 2012. Later on, a fire breaks out. It's the very thing they were trying to protect themselves against. So they do what you're supposed to do. They file a claim. And Tata AIG's response? Claim denied. Why? You guessed it. They pointed to that ridiculous basement exclusion clause, the clause that made the whole policy worthless from day one.
So you have to be wondering, how can a company even try to justify something like that? Well, it all comes down to the power of that fine print and the kind of contracts we sign every single day. See, this kind of policy is what lawyers call an adhesion contract. You know what this is. It's that stack of papers the big company hands you. There's no negotiation, there's no discussion. It's a take-it-or-leave-it deal, and they hold all the power.
And this isn't some new problem. A legendary judge named Lord Denning summed it up perfectly ages ago. He said the little man has no choice but to accept these terms, whether he's read them or not, no matter how unfair they are. And that's the exact power dynamic we're seeing here.
But, and this is a huge but, the law has a fairness check built in. Insurance contracts operate under a principle of utmost good faith. Now, we always hear about our duty, the buyer's duty, to tell the insurer everything. But here's the crucial part. It's a two-way street. The insurance company has that same duty, to act with fairness and be totally upfront with you.
So this whole mess, this clash between a one-sided contract and the duty to be fair, eventually landed in the Supreme Court. And the court basically put the contract through a common-sense fairness test. Now, the court used a few legal tools to make its decision. It said what the insurer did was an unfair trade practice, and that they had made a conscious waiver of that clause by inspecting the place. But the real heavy hitters, the concepts that are most important for us to understand, are what's called the main purpose rule and the Blue Pencil Doctrine.
The main purpose rule is really just pure logic. It says you can't have a tiny clause in the fine print that completely torpedoes the whole reason the contract exists in the first place. I mean, you can't sell someone an umbrella and then have a clause that says it doesn't cover rain, right? The court saw that the basement exclusion defeated the entire purpose of the insurance policy and said, nope, that can't be right.
So how did they get rid of it? They used something with a really cool name, the Blue Pencil Doctrine. And it's exactly what it sounds like. Imagine a judge taking out a blue pencil and just literally crossing that one nonsensical clause right out of the contract. That's what this rule lets them do. They can just slash the unfair part and keep the rest of the agreement intact. And poof, just like that, the basement exclusion was gone.
So, after all that legal wrangling, what was the final outcome for Texco Marketing?
And more importantly, what does this all mean for you and me?
The verdict was a total win for the little guy. The Supreme Court sided with Texco Marketing, loud and clear. It ruled that the insurance company could not collect a premium with one hand and then use a sneaky, self-destructing clause to take it all away with the other. In the end, fairness and common sense won the day.
And this is why this case is so important. It gives every single one of us some powerful protections. First, the main point of your contract is king. It beats the fine print. Second, what a company knows is key. If they know about your situation and insure you anyway, they're stuck with it. Third, good faith isn't just a suggestion for insurers, it's the law. And finally, you have the power to challenge unfair terms, and courts have the power to throw them out.
At the end of the day, this case makes you think about what a contract really is. It's supposed to be an agreement, a meeting of the minds. But what this ruling really says is that fairness is a part of that agreement, whether it's written down or not. Because an agreement to be treated unfairly, well, that's not really an agreement at all.